We must be respected. We are majority. We are the people. We are the government. We are the army. We are the air force. We are the police. We are everything you can think of. We determine who can do mining in Zimbabwe. We determine who can construct a railway line in Zimbabwe. We determine who can build a road in Zimbabwe. No other party can do so.
Honorable Luke Malaba is now the former Chief Justice of Zimbabwe.
Brought to you Hostels TV and radio in proud partnership with the Frederick Newman Foundation. On this show, we believe in dialogue, openness, and development. We look into issues that are afflicting our nation in the effort of providing free speech to all Zimbabweans, because we believe that where there's free speech, development of a nation happens. Now, this week we are going to be discussing a very amazing and topical issue, Constitutional Amendment number 2. And it's now an act, so it's Constitutional Amendment Act 2 that was put in law. And one of the major issues that it sought to do was to extend the life of the office of the Chief Justice from ending at 70 years to 75, subject to the President's approval. Now, we saw Chief Justice Luke Malaba looking to benefit from this clause. Actually, on 11 May, the President of this country issued a letter where he elected to extend the term of office of the Chief Justice from his 70 years to 75 years. The Zimbabweans who took to court to challenge this, they said this move was unconstitutional, and they wanted to be declared as such. On a Saturday afternoon, there was gnashing of teeth as the CJ was told to go home and rest. We are going to be discussing with the proponents or those who were behind this court challenge. Now, there was the Young Lawyers Association, which took upon itself as legal citizens of this country to protect constitutionalism, as they have said. And on the other hand, there was a non-governmental organization led by Musa Kika that also went to court. Now I have these two parties here with me to discuss and ventilate this issue on Freetalk, proudly brought to you by Frederick Newman Foundation and Hostels TV and radio. Now, thank you very much for joining me. I'll start with you, Musa Kika.
Yeah.
What informed you to take this bold position to challenge the extension of the office of the CJ and other judges? I'm sure that is in total 18 judges, both from the Supreme Court and the Constitutional Court.
17, correct. Yeah, well, Blessed, the straight answer is that it was an illegal move, and we were simply challenging illegality. We were challenging unconstitutionality, a departure from the founding values of our constitution, if you will, but a departure from the black and white writing in our constitution, that an amendment to the supreme law, that is the effect of extending tenure or time that one is in office, cannot benefit the incumbent. The inverse is true. A reduction in tenure for someone cannot affect the incumbent. So those are the two coins. It's there in our constitution, section 328, subsection 7. So what had been done, or what was about to be done in respect of the Chief Justice, was a direct violation of that provision of the Constitution by virtue of the amendments to the Constitution. Now there is a very interesting way that the developers of this amendment bill, or now act, sought to go around this. In their explanation, they were excluding the application of section 328 subsection 7 to the Chief Justice and judges of the superior courts, being the Supreme Court and the Constitutional Court. But there is nothing of that sort. There is nothing called exclusion. That does not amount to an amendment. So what was done was to amend the applicability of that provision insofar as the Chief Justice and judges of the Supreme Court and Constitutional Court are concerned. And we were challenging that illegality. We were not challenging the entire Amendment Act and its 20 plus variations or changes. We went to court on the narrow issue of the extension of tenure of the Chief Justice and judges of the superior courts.
Rumbi, you were working as a young lawyer and looking to establish what you said in statements after, the young lawyers, what they said in statements after the victory, that constitutionalism is a very important issue in Zimbabwe. And you being a young lawyer, one day you'll be old. But what gave you the courage of doing this? Because we know in Zimbabwe there's a whole lot of issues around fear, around failing to confront some of these issues. What pushed you? What spurred you to that?
Thank you so much for that question. And it's an important question because being a young lawyer, it means that we are officers of the court and we have a responsibility to the Constitution. We have a responsibility to ensure that we abide by the supreme law of this nation. And of course, a lot of fear is involved, but we need to act beyond that fear. Because we are responsible for ensuring that these matters are brought before the court. Remember that it is the role of the judiciary to interpret the Constitution. And in order for the judiciary to interpret the Constitution, we have to, as officers of the court, bring before the court those issues for us to unpack and for us to get to the bottom of those issues. Now, if me as an officer of the court, I'm afraid to bring those issues, then that means that we are not providing the opportunity for the judiciary to do its job, to interpret the Constitution, so that we are living in harmony and in abidance with the law. So it just has to do with going beyond that fear and knowing the greater responsibility that we have as officers of the court to ensure that the Constitution is upheld.
Andres, you want to come in there? I saw you also leading from the front on that and putting in hours to argue this matter through midnight. But I want you, as you come in, to give us the major highlights of the case for you. What really stood out in this case as you made those arguments?
Okay. I think I should commence by pointing out that in the matter that I argued, we had two applicants, the Young Lawyers Association of Zimbabwe, which is an association representing young lawyers. Then we also had Mr. Frederick Charles Moses Mutanda, who's a Liberation War hero. In that respect, I want to point out that the two applicants made out a case with regard to the constitution of the Constitutional Court, because the first point that was made was that in accordance with section 69(3) of the Constitution, the applicants had a right to a court of law established in accordance with the law. So their fear was that...
Speak in English.
Okay. their fear was that if the Mr. Malaba, who's the former Chief Justice, would have remained in office, they could not have access to a court of law properly established in law. So that was the basis of the case. But additionally, there was a complaint with regard to the inaction by the Judicial Service Commission and Mr. Malaba himself to advise the President that there was looming a vacancy in the office of the Chief Justice. And additionally, the complaint was also that Mr. Malaba sat in the Judicial Service Commission meetings, but he did not do anything. But he knew of his birthday, he knew of his retirement, but he did not do anything. So that inaction is what motivated the applicants to then lodge this application, principally seeking that the court confirms that Mr. Malaba could not benefit from this amendment, and that in any event he had also violated the Constitution in not activating the provisions of the law with regard to appointment of a Chief Justice.
You sought to teach a constitutional court judge constitutionalism in the High Court. Isn't that absurd?
It is regrettable, more particularly because Mr. Malaba sat as the chairperson in the Judicial Service Commission. He knew of his birthday, but he never attempted to activate the provisions of the law with regard to appointment of a Chief Justice. So that is regrettable in a constitutional democracy, that you have a person who shows a clear disregard of the Constitution. He was sitting at the helm of the judiciary, but he did not see the need to ensure that there is compliance with the Constitution. In motivating that point, I would want to draw your attention to the late Chief Justice Siku. His birthday was in February 2017, but as early as November 2016, he had already proceeded to advise the executive that there was need for his replacement to be appointed. He did that. He complied with the Constitution. But this gentleman clearly disregards the Constitution, and that is regrettable.
Mr. Kika, I mean, just listening to what Andre is saying, do you think that there was mischievous intent from the Chief Justice to unconstitutionally benefit in retaining power of the most important office in a democracy?
Yeah, I think there is no question, there is no doubt about that. Our applications, both of us, were vigorously defended, vigorously opposed by the institutions and the individuals who are supposed to be the chief promoters of judicial independence and rule of law and constitutionalism. The Minister of Justice, with him the Attorney General, the Judicial Service Commission, which in our case, in the Musa Kika case, they decided to jump on board as a respondent when we didn't need them and we did not cite them. In the case of the young lawyers, they were cited. But again, they vigorously defended that application. The Chief Justice himself did not depose to an opposing affidavit, but he sought to oppose through the Judicial Service Commission and the Minister, or at least as we understand from the papers we got, those two parties were also arguing, in opposition together with the Chief Justice. That's regrettable. But blessed, for you to subvert rule of law and constitutionalism, you also need lawyers who may not, subscribe to the notions of judicial independence. You need lawyers to advance constitutionalism and rule of law, but the other side is true. You also need lawyers to successfully subvert a constitutional system. That's how interesting the law is.
That brings me to a question that I've always wanted to ask lawyers.
Yeah.
I mean, do you guys have conscience?
I think the three of us and those who worked, in this application we do. That's why we were prompted to act.
Some would argue that you can sell your conscience to the highest bidder, because say someone had come, Chief Justice had come to hire you to defend, you would have said, no,
I can't do that, yes.
Everyone has a right to a legal attorney of their choice, and I swore an oath to defend and protect.
Yeah.
And you always use these funny things to justify defending things that you would probably know should not be defended.
That's why we speak of values. That's why our constitution in section 3 has values and founding principles. The reason is, in law you can essentially, arrive at whatever conclusion you want using whatever methods of legal sophistry. But if that is not in tune with the founding values, the ethos, the spirit of the constitution, it comes to nothing, right? That's why we have individuals that we call mercenaries, legal mercenaries and hired guns, who specialize in doing that. But the point I was making earlier was, the law is a very interesting social engineering tool, right, which can be used to build and to destroy. Apartheid was a legal system. Legal, proper, right, the legal system. Democracy is a legal system, right, proper. Constitutionalism, that's a legal system, right? And you have lawyers, in both systems who are driving and sustaining, right? Apartheid had judges and lawyers who were ensuring that that law was followed. Same with Zimbabwe. In our colonial days, we had judges and lawyers who were ensuring that system works. In the present day, we also have lawyers and jurists who are working extra hard to ensure that illegalities are committed, to ensure that illegalities are supported under judicial and legal cover. That's regrettable, but we have those individuals in society, blessed. But fortunately, we do have courageous and well-intending individuals and lawyers like the colleagues who we worked with in this case. Yeah.
You read the letter that was eventually written by the Minister of Justice. I'm sure you've had sight of it. What effect does that letter have to justice in Zimbabwe?
Well, before I get on that, I also just wanted to add on to the point that was raised by Mr. Akila on the issue of the interpretation of the law. And on that, I would just also want to applaud the bench. Because as much as we have different interpretations of the law and different ways in which we, if we try to move away from the values of the Constitution, then be lost in our interpretation of it. I applaud the judiciary, the bench who sat on that matter that we were representing, who were able to interpret the law in the way that, with the result that...
but it actually then brings us to the question that I put before, because the first instance was Judicial Service Commission opposed them sitting there. And immediately after the ruling, the Minister of Justice went on to label you night lawyers and night judges and a judge who is known for being anti-government. What does that do?
It's discouraging, especially from the perspective of a young lawyer like myself. I think it also can make the normal citizen who may not be a legal practitioner to lose confidence in the judicial system, to lose confidence in the laws that are supposed to protect them. It also discourages people who would want to bring forward their own cause, people who want to let their voice be heard. It's discouraging when people are criticized for standing up and bringing a matter before the courts. There needs to be an attitude in our society that is open and allows people to assert their rights. It should be viewed as something that is healthy. It's healthy. It's not a crime to bring before a grievance or an alleged infringement of your right That's why we have these bodies in place. That's why we have the separation of powers. That's why we have the role of the judiciary. And that's why we have the opportunity for the Constitution to be tested in litigation. It's all of us. It's a system that is supposed to work in harmony together with the overall objective to be to protect the rights of the citizens. And so that to me then rubbishes that whole value and whole idea around litigating around the Constitution.
So here the minister says, and I open court, we are also at loss as to how the Honorable Judge President of the High Court was excluded from being cited in the litigation, which included all judges of the High Court who have acted in the Supreme and Constitutional Court. Now, Andrea, why did you exclude the Judge President?
Okay, the first point in relation to that, Blessed, is that the Judge President is not interested in was not an interested party in the present proceedings, particularly in respect of the application that was lodged by the Young Lawyers Association. At the material time, he's the Judge President of the High Court. He does not sit in the Supreme Court. Of course, at given instances, he might sit on an acting capacity, but that was not the case in this instant. And the case in any event revolved around the interpretation of the law and as to whether or not Mr. Malaba could benefit from this amendment. So those are just statements that are made out of context. I believe it's an attempt to scandalize the court. It's an attempt to instill fear in the judicial system. But it is regrettable because such statements are made after a judgment has been rendered. If any party takes issue with a decision that has been made by a court of law, they are given the right of appeal. So that should be exercised, and that should then be tested in another court of law, as opposed to making reckless statements in public.
But this part of the statement says the situation now in this country is that there's a risk of judicial capture, where the judicial has been captured by certain elements, both within and outside Zimbabwe, who want to destabilize the Second Republic. What is your reaction to that?
I mean, I'm shocked. I do not understand how international organizations or how anyone could be able to destabilize a country by virtue of bringing an application to court to assert rights. Remember, these applications did not deal with any political aspect. They were solely confined to issues of law. If you note from the application, particularly the Young Lawyers Association, there was no reference to the president. There was no reference to anyone from the executive.
You directly attacked the authority of the president here. Because the president on the 11th of May wrote a letter appointing the CJ. And in your application, in essence, you were saying that the president is acting unconstitutional.
You see, Blessed, you raise an important question. If you look at what the law says with regard to an appointment of a Chief Justice, the process does not begin with the executive. It starts from the position of the Judicial Service Commission, which must recommend and advise the president that there is now a seat that is available. So the transgressions were not committed by the president, but it was by the JSC and Luke Malaba himself. So that is where the problem emanated from. Because remember, what the JSC was obliged to do was to recommend to the president. The president only acted after having received an application from Luke Malaba. So that is the problem. And those two entities are the people who the Young Lawyers Association and Mr. Mtanda were raising complaints against.
Musa, you stand accused of receiving money to destabilize the regime, because obviously if the Minister of Justice writes this, that there are people who are capturing the judiciary, it then doesn't start and end with the capturing of the judiciary. You then became the pawn to bringing in that application. How do you so plead to this accusation and allegation?
Yeah, well, probably the author of that statement has experience in capturing judiciaries. That's how they can be able to say that. How does an individual or an individual organization capture an entire judiciary? Citizens know their rights. Citizens know the Constitution. The fact that we step forward to vindicate our rights in our Constitution, which we wrote, doesn't need anyone to come and sponsor us to do that. You know, it's our rights, it's our court, which we appear. We are legal practitioners who practice in those courts. It's our right to have a properly and legally constituted court. We don't need to be sponsored by anyone to know that. We don't need to be sponsored by anyone to stop an illegality. You used the word, you attacked the president, you know, the authority that had appointed and written a letter. That's not an attack. You know, what we were seeking in these courts was simply a declarator. A declarator simply means a statement of the law, right? The judiciary stating that this is the position of the law and it must be followed. That's exactly what we did. We were not seeking a nullification, you know, of any law or any provision of any law. We were simply seeking a reading of the law and a pronouncement of the law as it is. And that's exactly what we got.
The net effect was to tell the king he's naked.
You cannot put something on nothing and expect it to rest. So if the president did something that is illegal, it's a nullity at law. So we didn't attack him, we didn't stop him from doing what he was doing. We simply got a pronouncement on the law, and that is what has prevailed.
But I want us to think, to clearly look at this and say, what next? You know, you've got this, the government has reacted and they are saying that they're going to appeal. How is this going to work?
Well, it's their right. It's totally within their constitutional right to appeal. They can appeal. And the moment we receive, you know, those papers noting the appeal, we will, of course, respond and act appropriately.
Because you crippled the appeal process by noting everyone in the Supreme Court, noting everyone in the Constitutional Court. So appeal to themselves.
Well, that wasn't our intention to cripple. We were citing respondents in the case of our application that we believe had an actual interest, and they did have an actual interest.
Because they defended.
Well, because they stand to benefit, you know, from the approach that has been taken to extend tenure of incumbents. That's exactly the reason why we joined them. So they have an interest. So our intention was not to cripple the appeal process. There are many ways to it, blessed. Our law allows the appointment of acting judges. Retired judges can be brought in to hear that appeal. Judges from other jurisdictions can be brought in to hear that appeal. That has been done in Namibia, in Botswana, in Lesotho, in Swaziland.
Who appoints? Because the Judicial Service Commission that appoints is also a respondent. In fact, they came in and demanded to be respondents.
Yes, we didn't ask them to come to this application. They came on their own. Blessed, the starting point is if the state, if the Judicial Service Commission, if the Minister of Justice, if the President had acted constitutionally and legally, we wouldn't have been here. So this is a crisis that these players got us as a nation into, open-eyed, fully aware of the implications.
For now, let us turn to listening to what has caused this problem, the unfolding events behind the scenes, and the issues that have raised through the court petition by Musa Kika and the Young Lawyers Association.
Justice Happiest Show, sitting with Justice Edith Mshore and Justice Helena Charewa, delivered a landmark ruling which reversed President Emmerson Mnangagwa's May 11 extension of office to the Chief Justice Luke Malaba by an additional 5 years. The ruling relieved Justice Malaba from office effective midnight of May 15. Justice Malaba and 18 other judges of the Supreme Court and Constitutional Court had sought to benefit from Constitutional Amendment Number 2, which effectively would have allowed them to retire at 75. Following a long-argued case which ran to Friday midnight, the 3 judges ruled that Amendment Number 2 had the effect of extending the term of office of judges of the Supreme Court and the Constitutional Court. They noted that in line with Section 328 of the Constitution, any extension cannot benefit the incumbent. It was a Saturday of sorrow for the Supreme Court and constitutional judges who lost to Musa Kika and the Young Lawyers Association. The judges face a dilemma because they cannot appeal to the Supreme Court or the Constitutional Court because they would be appealing to themselves. Attempts to get the matter dismissed on technicality by lawyers representing Justice Malaba and other judges and the Judicial Services Commission all fell in limbo. Insiders have said the High Court victory speaks more to internal fights in ZANU-PF than anything else. However, the winning party of Kika, Tendai Biti, Dark Coated and others were celebrating, saying it was a victory for the Constitution of Zimbabwe.
That's a brilliant judgment by the High Court. It's a bold judgment. It's a judgment which speaks to the issues we have always been worried about, constitutionalism in Zimbabwe, and we hope going forward that culture of constitutionalism will be maintained.
If Chief Justice Luke Malaba is to come back in office, do you think he will have the same command?
Well, of course, command is one element, and since you'll be in office, of course, you'll have to do what he's supposed to do. The command will be there, and I'm glad you used the word command. But in terms of integrity, that will be a very moot point, a very debatable point, because in terms of the Constitution, judges must be like a Caesarean's knife. They must be beyond reproach. So given the political shenanigans that have been going around, given the comments, then unhinged and incendiary attacks on the High Court by the Minister of Justice, you know, the integrity of the Chief Justice will always be an issue, and I can't certainly say you won't have integrity, but it will be very questionable.
Some are saying the judiciary is captured. What's your comment on that?
Well, I'm an officer of the court. I believe that the judiciary is independent in terms of the Constitution of Zimbabwe, and well, those who are saying a better place to say who captured it, when, where, how, and to what end, to achieve what. But you know, as a question of law and of politics as well, judges are political appointees at the end of the day, and they are also subject to political loyalty. So it happens in America, the Democrats nominate judges, the Republicans do the same. It happens in England, where we have judges also coming from a certain tradition of appointment. So I can't certainly say the judiciary is captured, but what I can certainly say, there are always political machinations behind the scenes.
Yeah, takambonza pamusoro payo at one time ndonyari runeza mazano concerning his office stay, whether they should extend his period at work or maybe they should make him quit the job.
Okay, what's your comment on the judgment?
Yeah, this is quite a controversial issue. Why am I saying so? It's because that guy is old, and he should learn to give other people opportunities, other upcoming justice individuals to work in the justice system. So he should give others opportunities to do all those things. I think it's high time that he just leaves his job and give other people chances.
Do you think the judiciary is captured?
The judiciary system, I don't think is captured, because in this case in Zimbabwe, for instance, it's pretty tricky for the justice system, the judicial system to be quite fair. Why am I saying so? Is the people who are there who are judges and chief justices, they are chosen by people in the government. So it's an obvious matter that they're going to choose, they're going to support the government. All those people who work within the government premises are the ones who will be promoted. So I can say it's one-sided. They're mostly concerned about single individuals. There are some people who benefit in the justice system. There are people who are benefiting. Those who are in power, right, are the ones who elect the judges, right? So it's an obvious matter that they are going to, the justice system is going to favor those people. And those ones who are not part and parcel of the electing system of the justice system, right, are the ones who are at a disadvantage. They're disadvantaged in terms of everything. Whenever they go to courts, they're not being there's being sidelines. For example, the Constitutional Court that was once prevalent in 2018, right? It went it favored the interest of the status quo, but it was a bit unfair to those who were not part and parcel of the ruling party. So I can say there's a lot of propaganda in terms of this justice system. It's propaganda, abuse of office that is prevalent. Thank you.
Okay, so what's your view regarding the whole issue around Chief Justice Luke Malaba?
Okay, that's a quite interesting one. What I'll do is that I will not get into the details because it's a matter that is already before the courts, and I'm not inclined by our rules to really comment on a matter that is pending. However, my interest would be to comment on a statement that was then issued. I'm not so sure who issued it, whether it was the Minister of Justice or it was someone else. Wow, but on that one, my view is that it was an unfortunate development, and there were certain comments that were made which I think scandalizes the courts. I don't think in a democratic society such as ours, an attack should be made on the judiciary in that manner. If you don't agree with the judgment, your right is to appeal. And if you're a litigant, I'm sure there's a lot of case law on that, on how you should not comment if you're a litigant. In Rich Namasa is an example. There's quite a number of matters that will guide you on that. So we wait. As I have said, it's an appeal. And as such, I cannot comment on the merits or demerits of it thereof. We'll just wait and hear what the Supreme Court will pronounce itself. But rather, any man who's concerned with the rule of law surely should be concerned with the comments that were passed. They were very unfortunate, and I wish that they be retracted, if as it were. But as a legal practitioner, I believe they were unfortunate. That would be all on my side.
Maybe lastly, would you say that the judiciary is captured or they are just claims?
Look, you should not make unfounded claims of corruption or of bias against the judiciary unless you have strong evidence. This is one of the reasons why judges are really protected in terms of how you can remove a judge from office. If you have any evidence that there's some capturing of the judiciary or that there's some bias, if there's any corruption or whatever you think is not correct, the appropriate role would be to instigate a tribunal, investigate everything, and then you bring that judge before a tribunal. That is the correct measure. You don't then issue a statement against a sitting judge without any iota of evidence at all. I mean, we must separate politics and the law. I believe politicians have a right at their rallies and wherever to make certain comments. But when it really comes on the judiciary, we should treat carefully because these are very sensitive issues. Yeah, that would be my comment.
Okay, thank you.
All right.
Okay, so this was the explanation and some of the lawyers and voices that we had coming from the streets and the legal profession. Now let us get back to the program.
Andrea, I just want to take you to Alex Magaisa writing in his Big Saturday read. He said that this amendment has an effect to go down in history as a Malaba clause because it was fast-tracked to the extent that it had to pass before he became 70. And by the time it was gazetted and by the time he turned 70, It's just less than 3 days, is it not? So would you think that this was directly for him?
It is difficult. It would be speculative for me, Blessed, to say it was for his benefit. But from the papers that we filed, positive allegations were made by the Young Lawyers Association that he failed to act diligently, more particularly because he was sitting in the Judicial Service Commission. So that inference was not challenged in court. It stands to be a fact. So in that respect, that is the only conclusion that I can then reach, that indeed this was meant to benefit him, because he did not challenge those arguments in a court of law, so they stand to be accepted.
And the time from which the law was gazetted, the time that he had already presented his health certificate to the president, what is your take to it?
Indeed, we do raise issue with that, because even in the papers we made allegations in relation to his failure to act, as I pointed out, and how he speedily obtained a medical examination and proceeded to lodge his application with the president. It is unacceptable, but the more important factor that arises is that even after he had lodged his application, he had been served with papers that showed that there was a challenge in relation to his appointment. But there was no attempt, at least, to advise the president that there's litigation that is pending. This matter is now pending before the court, and it is sub judice, and in that respect he must hold on to making any decision in respect of that application. That was not done, but it is regrettable that it was not done by someone who was our Chief Justice, who was the guardian of the Constitution.
Rumbi, justice must not only be done, it must also be seen to be done. Now, I'm a non-legal person sitting from the outside and thinking that all this time the Constitutional Court was in the hands of a person who needs a High Court judge to help him interpret the law. What does it do to me?
It would be discouraging, but I would want to assure, and I say this with the most enthusiasm and hope in the system. I would want to ensure the citizen that at the end of the day, there are people in these roles. People who may sometimes be flawed, may sometimes be misinformed, may sometimes misinterpret the law, and may sometimes need guidance. But we cannot look to people, because people can make mistakes. But we look to the system. We have hope in a system.
How do you trust a system where we know Justice Mbare right now? She's facing allegations of incompetence, but she has made strong point that the CJ was interfering in judicial processes. She has alleged judicial capture. And then you have the same CJ going before the High Court to be taught the Constitution. I mean, from where I stand, I'm thinking, no, law doesn't make sense.
And I understand that perspective, but we cannot stop asserting our rights as citizens. I think at that point, when that begins to happen, then we definitely have a crisis on our hands as a nation. Arguably. But myself personally, as an officer of the law, I will continue to assert that right, and I will continue to have faith in the justice in the judiciary and the justice delivery system. That we will continue to uphold the Constitution. I would like to think that that is the position, and as much as a citizen we can feel discouraged, it must not prevent us from continuously asserting our rights.
I saw a tweet from the presidential spokesperson, Judicial, pointing something about white, you being faces of a white, supremacist role, and you were defending white thinking because you had Doug Coulthard there, you had Drury's, and you post a picture you post your pictures there. How does it make you feel as a Zimbabwean, as a young Zimbabwean, where a presidential spokesperson goes to those lands to label you, inferior people?
The remarks made are totally insensitive and they are unacceptable. That is the reality. Because, it emanates from a failure or from a mischaracterization of the basis upon which those applications were filed. If you look at the case that was made out by both parties, it was in relation to an interpretation of the law. It did not relate in any way to the question of race or anything like that. So I do not know where those remarks emanate from, but with the greatest respect, it is unacceptable, particularly in a constitutional democracy, that someone makes disparaging remarks about people, more particularly because they've asserted their rights. It's an attempt, effectively, to instill fear in the young lawyers, to instill fear in the people of Zimbabwe, that whenever you assert your rights, you may then be characterized either as someone who is putting into place an agenda, which is not the case.
The Constitution does provide, I'm not sure which section, but it does talk about people not making statements that attack people based on their religion, race, and issues like that. Do you think that there could have been an overstep in terms of breaching the Constitution with such remarks coming from someone from that very high office?
Indeed, there's no doubt that there's been a violation of rights. There is freedom of expression in the Constitution, but you're not then allowed to make statements that are of such a nature. Statements that take us back to the colonial era. You cannot do that. It's totally unacceptable. It's totally regrettable.
So you've got a right to swing your fist, but it ends right where the other man's nose starts.
Indeed.
I'll come to you, Musa, for conclusions as we wrap up this program, proudly brought to you by Frederick Newman Foundation. Now, we were talking the constitutional amendment. We're talking about the issue that played out in our courts, the High Court over the weekend. One of the most amazing cases we have seen, going through into the midnight, and lawyers staying up alert and defending the Constitution, as they said. Musa, what are the take-homes? What are the major take-homes from this case, and what is your message to your government and the people of this amazing country?
Well, two things. Rumbi said something amazing about institutions and not relying on individuals. If we build our institutions, we are able to withstand illegalities that are thrust upon us by individuals. Our democracy and our constitutional system can be sustained beyond toxic individuals if we have systems that work. That's why even if you have the head of the judiciary who is disregarding the law, you have a lower court in the form of the High Court saying, hold on, this is not it. That's how institutions work. Institutions should be able to say to the president, hold on, Mr. President or Madam President, you are wrong here. This is what the law says. So people should never tire in fighting for institutions to be respected, institutions to function. The second point I would like to make is that when people raise their voices, it matters. People could simply have been silent. The lawyers, the young lawyers ourselves could simply have said, well, it has been done, and then we throw our hands in the air. But look at what we have achieved, even in this current context. Certainly this is not the end of it. Certainly this can be appealed. This may as well be overturned. Whatever happens, the point is people have to speak in defense of their constitution. They are the stockholders to the constitution. They own this social contract, which defines our collective aspirations and the terms of how we want to be governed. And the people should raise their voices in whatever way they can, legally, constitutionally. And to the government, I say respect the Constitution, respect the people. If you can't respect the Constitution, at least respect the people. But of course, you can't respect the people without respecting the constitution by inference. Yeah.
Counsel, your closing submissions.
I mean, my closing points would be that I'm most indebted with the courts for defending our constitution. The rule of law has been restored, constitutionalism has been restored, and myself as an officer of the court, I'm so happy that I was involved in asserting the rights of my clients in this matter. And the net effect of all this is that Zimbabwe as a constitutional democracy has actually shown that in any event, even if there's pressure, be it from other institutions that constitute the government, the judiciary can still stand and confirm that there is the rule of law in Zimbabwe. But in closing, I need to point out that this problem has chiefly been caused by failure to simply discharge constitutional obligations diligently and with time. If the Chief Justice had been appointed on time and if the law had been followed, we would not have been in this constitutional crisis. But I'm most grateful that the rule of law has been restored, and indeed Zimbabwe is a constitutional democracy.
Counsel, you are going to close this amazing discussion that we have had. The honor is all yours. Any strong points that Zimbabweans, especially Zimbabweans, would think, look, the government has declared judicial capture itself. You know, the Minister of Justice, who superintends over the justice system in this country, has declared judicial capture. And we have always felt that law and the constitution is the bulwark, is the last bulwark of democracy in this country. How do we win those hearts? How do we make the law matter in their eyes?
I would encourage every citizen to, first of all, educate themselves on the Constitution. We need to be empowered as to know our rights in order to enforce our rights. And we need to come from a position where we are confident in upholding our own rights. And knowing that we can ensure that there is continued rule of law. And to explain that coming before the judiciary in order to assert your rights is not a form of judicial capture. It is merely a citizen exercising the rights that they have been given in terms of the Constitution, and that is to be celebrated.
Amazing. Thank you very much. And I was surrounded by three lawyers. They call themselves learned colleagues. Now, I'm the informed colleague. But thank you very much for making your submissions in this my court, Freetalk, where we're ventilating the issue around Constitutional Amendment Act number 2, and we were looking at the issues surrounding the attempt to extend the stay of CJ Malaba at the helm of the judicial system in Zimbabwe, the Judicial Services Commission, the Constitutional Court, the Supreme Court, and all its intended arms. It is important for Zimbabweans, like Ru say, that we assert our rights. The law is made for the people and not the people for the law. We have to assert our rights to enjoy the benefits of the law, regardless of who is sitting in that chair. And an act of bravery, an act of courage, and an act of judiciousness has been done by citizens of this country to ensure that those rights are benefited by all people in Zimbabwe, to ensure that our courts are seen, not only known to be just, but they're also seen by everyone to be properly constituted, like Andrea said, and to ensure that they deliver the justice that they were set out to do. This was the Free Talk here on Heart and Soul TV and Radio in partnership with the Frederick Newman Foundation. And I am your host, Dara Blessed Mhlanga. Until next time, Thank you for joining us.
This is Free Talk in partnership with Frederick Newman Foundation, our partners in free speech. Free speech is the center of development of any nation.